Hello. I just wanted to talk a little bit more about the admissions and why that should be admitted and why it's quite strange that it wasn't. Obviously, I have to accept the order because the judge has given that order. So later, we can consider what we're going to do, but nothing obviously is going to happen before the hearing, not without delaying the hearing significantly. So yeah, we accept it. But what I argued was that, and this has to me always been the case, and other lawyers have agreed with me, that when evidence is relevant, it should be admitted. So we're looking at the evidence of all the sales and execution that happened for much less than market price. We're looking for the evidence of everyone that filed an affidavit. Surely these things are relevant. Obviously, they're relevant. Now we do have other evidence, thankfully, in our papers that there were sales and execution, but this is evidence that was relevant. So that's the first thing that surprised me. My senior counsel friends that have been advocates for many years backed me up on this and said, no, if it's relevant, it will be admitted. That's what I expected. That's the first thing. The second thing was, the banks argue that everything must always be on your initial papers, like your founding affidavit, their answering affidavit, your replying affidavit. That's it. But that's not the case. I mean, supplementary affidavits after the initial papers are filed regularly in court matters, and they're usually admitted if they're relevant. So the banks are wrong there, and I've provided lots of case law and evidence and so on. Secondly, what I also argued was, how am I supposed to file things all at the beginning when many of the people that filed affidavits I didn't know then. I didn't know them. I'd never met them. How could I have filed them at the beginning? So if the evidence is relevant, which it is, then I argued that they should be admitted. And the other strange thing about the order was it didn't distinguish. I would have thought that it would have said, okay, we'll admit this, we won't admit this, we will admit this, we won't admit this. So that was a bit strange, but there's nothing we can do about it now. If we have to go and appeal, then it will be relevant then, and it may help us that this evidence was excluded. If we, and these are all just contingencies. I'm not saying that these will happen, but if we start the class action again, it'll be quicker the next time. Then we will obviously include all these affidavits and Garth Seepsman's affidavit and all kinds of other things at the beginning, because we'll have everything at the beginning. So yeah, just to let you know a little bit more about that admissions. I mean, I argued it hard, but the judge decided against us. So we pick ourselves up and we argue our case without it. But as I say, as I said in the other one, it doesn't affect any individual persons. You'll still, if we have a negotiation with the bank, we still have the affidavits. We will still argue on your behalf if you've filed one. And if we get the class action certified, you'll still be part of it. If you'll still be part of it. So don't worry in that respect.